So what is the insurance company's estimate? It's not the gospel. It's not what you're entitled to. It's not what any builder can do it for, unless the guy that came out is a builder, licensed, workers' comp, the whole 9 yards, and he works and is licensed in the city of Long Beach or Rockaway or wherever he is. If he's the builder that can come out and do the work, that's a real estimate. So what's this guy giving you that overrides your builder who's saying, look, I'm doing you a favor. I'm showing up because I got a lot of other work. And by the way, I can charge people a lot more money. I'm charging you this. It's what the market bears right now. Isn't that the number? Why are we writing estimates? Can't I just fix my house and give you the receipts? Isn't that what the cost to repair or replace is? So who is this guy? And who's listening to him and why? So if you look in your policy, it says that you have a responsibility to present your claim to the insurance company. Why are they writing an estimate for you? So far, if you have a claim and you called them up and they came out and they wrote an estimate, you didn't make a claim. So, yeah, they're going to write what they want. It's your obligation to present a claim to them. So, what are you presenting? What do you have to present? And they have to respond to you. They can't just say, nah. So you have to document things. Raise, rebuilding the ICC coverage. There's a disclaimer that comes with anybody and everybody who talks about ICC coverage. And what the FEMA program is your community, City of Long Beach, whatever community you're in, made a deal with FEMA years ago to replenish the beaches or to participate in the federal insurance program. By participating in that program, they're selling you insurance, they're giving you a certain rate, they're adjusting your rates by your community's participation in their programs, what the community does to save the beaches, by the community changing the building codes to minimize losses. So your community has agreed to a program. Your community will agree to more programs. What happens in your policy, there's a coverage D, as in David. It's actually not on your deck sheet. You have building, you have contents, there's D. D is ordinance of law or ICC coverage. It doesn't cover just to lift your house up. It actually has coverage to waterproof your house. So if you weren't rebuilding your house and you were digging around your foundation and waterproofing it or doing something like that, if your community participates in that program, you can get that money. The very important things to know about coverage D, increased cost of compliance, and you'll see in there, you can look in your policy, it'll say compliance activities eligible for payment are elevation, flood proofing, relocation, or demolition, or any combination of these. Somehow, people believe I have to lift my house or tear it down. You can be eligible for money under that program, which is limited to 30 grand. There's other things that you're limited to, which I'll explain, but it's available to you. However, that disclaimer, your community worked something out with FEMA, and the community has those answers of what you're eligible for. Coverage D, I went over it. Here's the catch. It's $30,000, but it's for the building, and all of your payments for building are capped at $250,000. If you have a total loss with $150 and you're eligible for the $30,000, you can get $180,000. If you have a total loss of $250,000 and whether you're eligible or not, you're not getting any more money. I'm going to make the recommendation that before you go apply for it, you look at what your settlement is. Before you go wave the flag and say, hey guys, I'm 58%, I'm 90%, and I need that money. Oh, I actually got all the money? Well, I raised the flag, it's me. I qualify, so I'm supposed to raise my house. and if I don't, then my rates are going to go up, or I'm not going to be insured for this or that, whatever your community agreed to. So before you go down that path, get some information, ask what you're eligible for. There's a whole question of 51% of what? Of what your market value is, of what your assessed value is, of the replacement cost of your building, of your policy limits. What exactly is the 51% that makes you eligible or not? Your community will have that answer. Then you have to actually see if you've been comparing the right things, because you may not be eligible. Now, if you have a small bungalow that's 600 square feet, you could have 51%, more than 51% of damage just because of the cost to fix what's there. But you may not be 51% of the value because you're right on the beach and you have a higher value home. This is from a FEMA adjuster. Keep in mind that if she qualifies for ICC and commits to it, then it can open her up to a can of worms. She will need to raise her home because that is the purpose of the ICC. He's actually wrong there, but you get the concept. If she doesn't, they will keep the money from the next flood and back charge her higher premiums as well. And this is basically what he was told at his FEMA class. And the guy who wrote this has a very high level of certification with FEMA. So, same guy, this is the email. So in the case I've seen, the insured was insured for $250, et cetera, et cetera. What he's saying is, don't let the policy limits deter you from seeking the ICC before checking into how the local community valued the property. You're right back to the same place of, you have to start with your community. And you have to get the information to be able to turn around and apply it. Then you're applying it to what your settlement is, what your damages, and what your coverages are. If you only have $150,000 or $100,000 of the building coverage, you can get that other $30,000. It's in addition to that, as long as it does not exceed your $250,000. Identifying your damages. This is going to be important into moving forward. You have to identify. You had emergency work done. It's identified. You have invoices. You have those things. You have remediation. It was done. You have invoices. There's photos. There's whatever you need. You have your estimate of repairs, and you have to present your claim. What you have to also do is separate wind from flood. You have to make a wind claim to your wind carrier, flood claim to your flood carrier, and you have to understand that if you had 4 feet of water in your house, nobody can say that the wind carrier only pays for 4 feet up or the flood carrier only pays for 4 feet down. So if you have a stain on your ceiling and it runs down your wall, you need a drywall repair, you need an insulation replacement if it's an exterior wall that's insulated, or there's insulation in the ceiling. You need those done, and you're also entitled to paint the whole room. The insurance company can't say, I'm stopping at 4 feet. You just can't. They do it, and it makes sense because they say, oh, no, 4 feet down is flood, and this is this. If you have a backup of sewers and drains, and your sewer backs up, and you have a foot of water in your house before the flood comes, you're entitled to, from your homeowner's carrier, subject to the limit of backup of sewers and drains, whatever it would have cost for that damage. So you had poop on your carpet. You're entitled to new carpet. You had it on your couch. You're entitled to a new couch. It was on your drapes. It was everywhere. What would it have cost if you made that claim without the flood? If your homeowner's policy covers that with no limitation or limit up to your coverage, you're entitled to it. But you actually have to make that claim. You have to put it together, and you have to get what it would cost to do, and you get somebody who's a remediation company and say, I was here, I was looking down, I had 1.5 feet of sewage. Yes, the flood came after, but you want to get paid from your homeowner's company for what's covered. And then, by the way, a lot of that's subject to replacement costs, so you're going to get more money. And then you don't have to get that money from FEMA. But what really happened when the flood came in after the sewage is the flood washed down the sewage and made it less toxic. So the remediation for the insurance company would have been less. They're getting a benefit of the flood, but they still owe you for what the backup of sewers and drains or backup of sewage did to your house. if you have coverage for it subject to the limit in your policy. Later, we're going to address an issue with why did your sewers back up, and that's going to be coming up next because that's an important piece in preserving your rights, filing a proof, filing lawsuits if you have to. So, statutes of limitations and what you need to do. We've identified 3 different types of statutes. The FEMA, NFIP, statutes, guidelines, policy provisions. These are all the things set in the FEMA policy or in the FEMA guideline or in their bulletins that are telling you dates. Requirements and dates. There's very important information in there. Insurance company deadlines. Your homeowner's company, your insurance policy with your homeowner's carrier has deadlines in it. There are New York State statutes that you can bring a suit however many years. The attorneys can tell you if somebody did something to you, you have a statute of limitations of X. What's very important to know is, and I'll address it, FEMA doesn't really care what your state laws are. They're the federal government. And in New York, you can contract out of a statute. So if your policy says you have 2 years to do this, you can't sue if it's after 2 years. That overrides the state law. And there's case law on it, it's a fact. So, addressing FEMA and the NFIP. If you read the policy, it says you have 60 days from the date of loss to file a sworn statement proof of loss. NFIP submitted a bulletin, they extended it to 90 days, then they extended it to 1 year. They also submitted a bulletin saying they're waiving the proof of loss. You know, that's really subjective, which we'll get into.